I think we all agree that we're here today because there was a tragedy. Lucy died. And it's painful. It's painful for everybody to think about it, hear about it, talk about it. And over the course of the trial, we'll have to relive those moments, and George Pino is going to have to relive those moments. He loved Lucy. He'd known Lucy since she was a little girl. He loved Lucy like a daughter, like his own daughter. The state admits this was not George's intention for this to happen. He did not intend to crash into a marker. He did not intend for anybody to be hurt. His own daughter, his own wife, his own body was on that boat. He had traveled on that boat safely through that channel many, many times. Many times. And he was celebrating his daughter's 18th birthday with some of the best friends his daughter had.
9 seconds. That is all the time that passed between the moment George Pino's boat began to veer and the moment it struck marker 15. 9 seconds. 2 football fields of open water, a clear day, calm seas. 14 people on board, his wife, his daughter, her closest friends since childhood, and in those 9 seconds, a 14-year-old girl named Lucy Fernandez ended up trapped under a capsized hull in the waters off South Florida. George Pino, bleeding from his head, suffering what testimony would later confirm was a traumatic brain injury, reached under that boat and pulled her to the surface. His efforts failed. Lucy died, and then the state of Florida charged him with a felony. The question the jury had to answer was not whether a tragedy occurred. Everyone agreed it had. The question was whether 9 seconds of inattention is a crime. By the end of this video, you will understand exactly where Florida law draws the legal line between human error and criminal recklessness, and why that line matters to every person who has ever operated a boat, a car, or any vehicle carrying people they love. On September 4, 2022, George Pino, 57, was operating a 29-foot Robalo vessel in the waters near Cutter Bank Channel in South Florida. He was charged under Florida law with culpable negligence, a criminal standard requiring proof that his conduct was reckless, grossly careless, and consciously indifferent to the safety of others. Defense counsel argued the case before a Florida jury. Prosecution was conducted by the state of Florida. The case centered on a single collision with channel marker 15 during a return voyage from Elliott Key to Ocean Reef.
I want to begin the morning with the morning of September 4th, 2022, when all of the families were at Ocean Reef, gathered to celebrate the birthday of Mr. Pino's daughter. There were several families there, and they'd been there, some of them had been there that weekend. And it was going to be a glorious day. Mr. Pino, he was sort of known as the camp counselor. What he's been with these families for many years. He was organizing events, and that day he had organized a gathering. The day would start off with a virtual mass for the kids that woke up. Then Mr. Pino had organized a little pickleball gathering, a tournament. After the pickleball tournament, they were going to all convoy by boat to Elliott Key, call it Billy's Point or Coons Point, and they were going to spend several hours enjoying the beautiful weather. And it just happened to be an ideal day for boating. The seas were calm, no wind, no rain. And so after the pickleball tournament finished and all the kids gathered up, Mr. Pino was going to operate the vessel.
George Pino was not a reckless man by any account in the record. He was the kind of person other families trusted without question, the one who organized the pickleball tournament that morning, who had navigated that same channel safely on numerous prior occasions, who had his wife and daughter on board that day. He had owned and operated that boat for years.
The 29-foot Robalo, a well-built boat, has been in fabrication for decades. It was equipped with twin 300 horsepower engines. The boat actually is rated to handle even larger engines. Mr. Pino had navigated that course many times. The GPS data that you heard the prosecutor tell you about will show that he had navigated that area many times. There were 14 people on board: Mr. Pino, his wife, his daughter, and the daughter's girlfriends. And they navigated from Ocean Reef the distance to Elliott Key and then anchored in that area. Other boats joined the festivities. And you heard that
He accepted responsibility for getting those passengers home safely. That acceptance of responsibility was never in dispute. What was in dispute was whether his failure, if that is even the correct word, crossed the legal threshold from tragedy into crime. Defending a felony charge in Florida costs tens of thousands of dollars in attorney fees, expert witnesses, and court costs before a single witness takes the stand. George Pino bore that cost while also carrying the weight of what happened to Lucy. The prosecution's case was built on a specific theory of criminal recklessness.
essentially an internal autopilot, as he had done many times before. On this one occasion, on this one time, something went wrong. Mr. Pino, according to the state's expert who you will hear testify, somehow lost situational awareness, meaning he must have lost track of the markers along the way, and he elided or crashed into marker number 15. He wasn't intending to do it. He wasn't trying to come as close as possible and see if he could just skim across that channel. This was pure and simple an accident.
Objection to argument, Your Honor.
The evidence will show that Mr. Pino had no intention of putting anyone's life in danger. He wasn't intending to try to come as close to the marker as he possibly could. But on that day, there was no other boat coming at him. It was a clear day, and his destination, Ocean Reef, once that boat would have cleared marker 15, it was wide open bay until Angelfish
The
Creek.
state argued that Pino was traveling at 47 miles per hour through a marked navigational channel, that GPS data placed his vessel on a steady course that gave him at minimum 9 seconds of visible warning before the collision with marker 15, and that any reasonably prudent operator would have seen that marker and adjusted course. They argued that the presence of 14 passengers, including children, made the speed not merely fast but criminally indifferent. They produced GPS track data showing the vessel's path and trajectory. They argued the evidence of alcohol consumption, 2 beers, which Pino acknowledged, was relevant context.
The evidence in the case will be that Mr. Pino was observed with a beer. He admitted later on he'd had 2 beers. And it's not 2 beers in quotes, as the prosecutor did in her opening statement. That is the evidence. The evidence will show there's not one more beer than 2. Not one more. It was 2 beers over the course of several hours, 2 or 2.5 hours. This was not the first time Mr. Pino and these adults had engaged in these kinds of gatherings in the past. The other adults there, Mr. Suarez, Mr. Pardo, they knew Mr. Pino. They too had enjoyed the afternoon with Mr. Pino. They observed Mr. Pino. All the adults that were there that day were satisfied that Mr. Pino was not impaired.
They argued that the kill switch, not required by law but available, was not deployed. And they argued that the combination of speed, inattention, and the absence of precautionary measures that could have been taken constituted culpable negligence. Conscious disregard for human life. Most people following this case assumed the GPS data was the prosecution's strongest evidence. It was not. Here is what almost nobody noticed during the opening arguments. The defense attorney disclosed that the GPS device on Pino's own vessel showed marker 15 as being up to 15 feet from its actual location in the real world. The GPS data the prosecution intended to use to demonstrate that Pino had 9 clear seconds to react was generated by the same device that incorrectly placed the very marker he hit. That detail passed without significant attention. It would become central to everything.
Now, the GPS, interestingly, you heard the prosecutor say the GPS is not biased, it is not subject to money, privilege, or power, I think was the words that the prosecutor used.
Judge, objection to argument.
No argument, counsel, what the evidence is.
Interestingly enough, though, the GPS is not perfect either. You'll see that the GPS records data. What it does is it simply records points in time as the boat is moving, and then it does computations. This GPS, as their own expert will show, sometimes makes what I'll just describe as errors, computational errors. In one instance, it registers at some point in time the boat is traveling at 77 miles an hour, but the expert knows that that's not possible. The boat can't achieve that. The GPS is making an error. The GPS will show a boat traveling over land when we know the boat is not traveling over land. It's fallible. And to the point of this case, the GPS on Mr. Pino's boat, which tracks where the boat went according to the global position satellite, the track on the GPS data that you will see actually shows that the marker 15, the one where the accident happened, is not exactly where it is in the real world. On the GPS device in Mr. Pino's boat, the marker is many feet away, up to 15 feet away from where it really is on the planet Earth. And so the track that you will see, if you look at the track, it would appear that Mr. Pino's boat, the Robalo, never actually alighted with the marker. But we know it did. And that's not the product of some intentional mistake by anybody, but the marker on the GPS, Mr. Pino's Robalo, is not exactly where it is on the planet Earth. Now, the GPS,
Under Florida Statute Section 327.33, operating a vessel in a culpably negligent manner is a criminal offense. Culpable negligence, meaning gross and flagrant negligence demonstrating a reckless disregard for human life, is a higher standard than ordinary civil negligence. The distinction matters enormously. In civil court, a boat owner can be found liable for failing to exercise reasonable care. In criminal court, the state must prove something qualitatively different, that the defendant's conduct reflected conscious indifference to consequences, not merely an unfortunate failure of attention. The legal question at the heart of this case was whether 9 seconds of lost situational awareness on a calm day in a vessel rated for higher speeds, with no posted speed limit in that channel and no legal requirement to travel slower, constitutes criminal culpable negligence under Section 327.33. That question has never been simple, and the GPS problem made it harder. The defense cross-examined the state's expert on GPS reliability. The expert acknowledged the device had registered speeds of 77 miles per hour, physically impossible for that vessel, demonstrating its computational fallibility. The expert acknowledged the GPS showed the boat traveling over land at certain points. The expert acknowledged that marker 15 was displayed on the device at a position up to 15 feet from its actual location. Each acknowledgement was one more concession. Each concession returned to the same point. If the GPS is wrong about where the marker was, How certain can we be about what Pino saw and when?
that you will have to answer. Was Mr. Pino reckless? And I submit to you what the evidence will show is that Mr. Pino was human. He was human. And that something happened that we may never know. No one will be able to say why he was distracted in those last few seconds, where 9 seconds or however many seconds it was, and did not appreciate that the boat was going to collide with the marker. Had he seen it, we know he would have turned. Nobody's suggesting he wanted to hit it. The state's suggestion that it was speed, that's not a factor. You'll hear that there was 9 full seconds, 2 football fields between the time the boat started veering towards Ocean Reef, towards Angelfish Creek with that marker in the middle, 9 full seconds. At any point in time, if Mr. Pino realized, oops, we're headed towards the marker, all it would have taken was a slight turn of the wheel, and none of us would be here. And the state's theory is his failure to turn the wheel should bring him into a criminal courtroom.
That question was unanswerable, and an unanswerable question about the state's primary objective evidence is not a small problem. In real-world criminal law terms, reasonable doubt does not require proof of innocence. It requires only that the jury cannot be certain beyond a reasonable doubt that guilt has been established. A GPS that misplaces the marker Pino struck by up to 15 feet while simultaneously reporting impossible speeds is exactly the kind of evidentiary fracture that reasonable doubt is designed to protect against. A competent prosecution preparing this case would have independently verified the GPS data against physical survey coordinates before presenting it as objective proof of what Pino could see and when. Under Florida Rule of Criminal Procedure 3.220, the prosecution has a disclosure obligation that includes making its own evidentiary reliability assessments available to the defense. The GPS fallibility issue was not a surprise. The state's own expert was aware of it. A properly prepared prosecution would have addressed it affirmatively during direct examination rather than allowing it to surface through cross-examination as a series of damaging concessions. Additionally, under the culpable negligence standard of Section 32733, the prosecution needed to establish not just that Pino failed to see the marker in time, but that this failure reflected conscious indifference, a mental state, not merely an outcome. The absence of speed limits in that channel, the calm conditions, the boat's rated capacity, and the multiple prior safe transits of that same route were all facts the prosecution needed to account for before filing felony charges. The cost of that filing, to Pino's finances, to his reputation, to the years of his life spent in criminal proceedings, represents a burden the state's charging standard is supposed to prevent from being imposed without sufficient evidentiary foundation. What the defense attorney accomplished legally was the systematic undermining of the prosecution's primary evidence by using the state's own expert to expose it as unreliable. This connects directly to the culpable negligence standard under Section 32733 and to the broader principle that criminal charges require proof of a mental state. Conscious indifference, not merely proof that a bad outcome occurred. At this stage of the trial, the defense's goal was straightforward: establish that the objective evidence the prosecution relied upon was fallible, and then ask the jury whether that fallibility created reasonable doubt about whether Pino consciously disregarded the safety of his passengers or simply failed to see something on a calm day in 9 seconds. Most people believe that if someone dies during an activity you were responsible for, criminal liability follows automatically. That is not what the law requires. Culpable negligence is a higher gate than that, deliberately so, because the alternative is a criminal justice system that charges every accident as a crime. The prosecution stood before the jury and argued that accountability demanded a criminal verdict.
What we're here to resolve is whether the state proves that Mr. Pino, that day, that time, in those 9 seconds, as they would say, was acting recklessly because he was traveling on his boat, surrounded by his loved ones, wanting to go back to where they started the day to celebrate his daughter's birthday. The state will feature photographs of visuals of that day. For example, I expect they're going to show you that Mr. Pino's boat was carrying all the empty glassware and cans from the beverages, including the alcohol beverages that were consumed that day. Mr. Pino's boat, his wife will tell you, she took the responsibility of gathering all the empty bottles, all the empty cans, all the trash, to make sure it was disposed of properly and not left out at Elliott Key. And so when you see those bottles and you see those cans, you'll understand that Mrs. Pino and Mr. Pino were acting in a way that you would expect people to act when they've gathered together for a day of recreating at Elliott Key. Don't leave your trash behind. You may see very difficult pictures of the events, and of course they're going to
Lucy Fernandez was dead. She was a child. She was on that boat because her family trusted George Pino. He was operating that vessel at 47 miles per hour. He had 9 seconds to see that marker. He did not turn the wheel. The law does not require that a tragedy be intentional to be criminal. It requires only that it be reckless, and leaving 14 passengers, including children, at 47 miles per hour through a marked navigational channel without the focused attention that responsibility demands is reckless. The GPS showed what it showed. The state's expert acknowledged the fallibility, but maintained that the core data was reliable. The prosecution asked the jury to look at what happened and recognize that it did not have to happen. The defense answered with equal seriousness.
But that evidence will not answer the question of whether the state is proving that Mr. Pino acted recklessly, whether he acted with culpable negligence, intentionally, knowingly, purposely, consciously, indifferent to the consequences, that when he was traveling at 47 miles per hour in the wide open bay with one marker to go and plenty of space, whether if he looked at his speedometer and saw it was going 47 miles an hour, he should have said to himself, wow, this is really a dangerous speed. When the Robalo boat is built to handle even much more speed than that, all of the passengers were seated. There were the right number of life preservers on the boat. He didn't have a kill switch on. It's not required by law. And so to the extent that you'll hear evidence of other features of a boat or other safety features that can be employed, we're not here to decide policy of whether we should require safety switches, kill switches. And given that you know that in that channel there is no posted speed restrictions at all, not then, not now, the evidence will show that the speed at which Mr. Pino was traveling was perfectly appropriate given the conditions of
The channel had no posted speed limit, not in 2022, not in 2026 after Lucy's death. The boat was built for higher speeds. Every passenger was seated. Every life preserver was aboard. George Pino had made that voyage safely many times. He was not impaired. He was not distracted by a phone. He was not racing. He was simply going home. Something went wrong in 9 seconds. The GPS that the state called objective was the same GPS that showed the marker 15 feet from where it actually stood. The state had not established what Pino saw or when. The state had not established that he was consciously indifferent to consequences. The state had established that a tragedy occurred. Tragedy and crime are not the same word.
But even so, somebody died. Even so, somebody died. Mr. Pino will have to live with that.
Judge, objection to argument.
No argument, counsel, please. Ladies and gentlemen, this is opening statement. Lawyers advise what they believe the evidence will show. Thank you. Go ahead, counsel.
Let me say he wasn't texting, he wasn't on the cell phone, but he was the operator of that boat. At the end of the day, it was on him. It was on him to get those girls back to Ocean Reef safely. That was on him. He accepted that responsibility and it was on him. But the law...
The one question neither attorney fully resolved was this: does the law of culpable negligence draw a line between a person who was conscious of the risk and chose to ignore it, and a person who was simply, momentarily, catastrophically unaware? And if it does, which side of that line did George Pino stand on in those 9 seconds?
As it will be instructed, I submit to you, tells you that even when we fail as humans,
Objection to argument, Your Honor.
Counsel?
even though Mr. Pino may have failed as a human to avoid this...
The jury returned its verdict, not guilty. The verdict was legally correct under the culpable negligence standard as Florida has defined it. Culpable negligence requires proof of a mental state, conscious indifference, gross and flagrant recklessness that goes beyond the failure to prevent a foreseeable accident. The Florida Supreme Court has consistently held, in cases including State v. Green, that the distinction between negligence and criminal culpability lies in the defendant's awareness of the risk and their conscious choice to disregard it. This is the same constitutional principle the Supreme Court examined in Morissette v. United States 342 U.S. 246, 1952, which established that criminal liability requires proof of a guilty mind, a mens rea, not just a harmful result. Applying that standard to what the evidence actually showed, a boat operator with no speed violation, no posted limit, no impairment, no prior negligent act, and a GPS system the state's own expert acknowledged was fallible. The jury's conclusion that the state had not proven conscious disregard beyond reasonable doubt was not only defensible, it was what the law required. Criminal law is not designed to punish every tragedy. It is designed to punish those who choose, consciously and recklessly, to endanger others. The moment we stop requiring proof of that choice and begin convicting based solely on outcome, every accident becomes a potential felony, and every person who makes a human mistake becomes a criminal. Lucy Fernandez deserved justice. Her family deserved answers. What they deserved was a thorough investigation and an honest assessment of whether the evidence supported a criminal charge before that charge was filed. George Pino will carry what happened for the rest of his life. The law asked whether he should also carry a felony conviction. The jury said no. Next, we examine a case in which a boat operator was convicted after prosecutors established not just what happened, but what the defendant knew in the moments before it did, and how that single evidentiary distinction determined everything about the outcome. Was the prosecution's decision to bring felony charges against George Pino a good faith exercise of the state's obligation to seek accountability for a death that did not have to happen? Or was it an overreach that used Lucy Fernandez's tragedy to test a criminal standard that the evidence was never strong enough to meet? And if it is the latter, what obligation does the state carry when it charges a person with a crime and loses?